My name is Bill Hamilton. I'm a professor here at the University of Florida College of Law, legal skills professor. I'm also the executive director of the University of Florida e-Discovery Project. On behalf of Laura Rosenberry, our dean, and the faculty and students at the University of Florida Levin College of Law, I would like to welcome Jay Grenig, who is our 2017 Fall e-Discovery Distinguished Speaker. Mr. Grenig, Professor Grenig, is a professor of law emeritus at Marquette University Law School. He has also taught at Pepperdine Law School, Willamette University College of Law, the University of Southern California Graduate School of Public Administration, the University of Southern California Graduate School of Public Administration, Cornell University School of Industrial and Labor Relations, and Vermont Law School. Professor Grenig has served as an arbitrator or mediator in over 2,000 labor and employment cases. Professor Grenig is the former chair of the Labor and Employment Law Section of the Association of American Law Schools and has served as a consultant to the National Commission on Employment Policy. In addition to his work in the field as a practicing arbitrator, and as a law school professor, he's a distinguished and prolific writer. Professor Grenig is the author or co-author of numerous books and articles, just including at the top of the list a book on international commercial arbitration, West Alternative Dispute Resolution, Case Preparation and Presentation, E-Discovery and Digital Evidence, Electronic Discovery Records and Information Management Guide, and the Handbook on Federal Civil Discovery and Disclosure. Professor Grenig is a contributing editor for the American Bar Association's preview of United States Supreme Court cases. He is also a member of the National Academy of Arbitrators and the American Law Institute. And finally, he is also a fellow of the College of Labor and Employment Lawyers. It is my distinct pleasure to welcome Professor Grenig to the University of Florida Levin College of Law, who will be speaking on ADR meets ESI. Professor Grenig.
Thank you. I'll stay here. I take it the sound level's working okay, good. I'll avoid the feedback on this thing. I want to thank Professor Hamilton for inviting me, and this is incredible. I thought I was giving a eulogy when I saw all that up there. But I tried to explain to him, I've been teaching in Wisconsin. I've lived all around Arizona and California, but Wisconsin, which I very much love. But very definitely 4 seasons. You're from Philadelphia. 4 seasons, okay. It was warmer in Delafield, Wisconsin, Friday and Saturday than it was here. I keep saying, Bill, February. February is when you invite me to speak here when it is a lot warmer here, not the reverse. I mean, I came here to get cool. I've been invited to do like arbitrations, labor arbitrations in Arizona. You think, oh good, I could go down, February, March, and get a little warmer. No, August in Arizona, Phoenix. That's the. I teach ADR and I teach CivPro and I teach electronic discovery, which is a branch of CivPro. I've been given an interesting challenge today in that it's merging the two. Usually I teach, and I say CivPro when I teach it. It's about trying to avoid getting to the merits. It's about avoiding having to tell the truth. It's trying to get it dismissed on something. Those of you that took CivPro, right? Iqbal, if anybody here understands Iqbal, raise your hand and I'd like to talk to you later. Oh, but it's about trying to get the case thrown out before you have, and what is it? Less than 5% of cases, civil cases that are filed actually go to trial. There's some settled, some are abandoned, some are dismissed, etc. Dispute resolution, we're trying to resolve a dispute. We think it'll be better for the parties to do it. Today I'm going to talk about ADR, alternative dispute resolution, and electronically stored information, the discovery of it, ESI. I'll try to avoid acronyms too much. Everybody that does electronic discovery keeps talking about ESI, ESI. Go out for a social event Friday and at the club, turn to the person sitting next to you. Hi, would you like to hear about ESI? they're going to go, oh, are you psychic? No, 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 no. Oh, you work on the environmental issues? No. I mean, most people don't know ESI, and one of the problems with acronyms, it's sort of our secret language. You know, so I'll talk to you a little bit about it. Could pass for being from the Middle East or anywhere in their age. I'm the one who gets the extra search. In Narita, Japan, in Narita Airport in Japan, sir, we're going to have to give you a special extra search. Oh, very good. I don't know. Do I look like a problem? I don't know. I'm not going to have a lot of citations in this thing. I'm sorry. Not a lot of citations because we're talking about ADR and arbitration, which is not. It's amazing, by the way, with arbitration as it grows. I can't believe the hundreds of cases every week. I get the thing from Westlaw, you know, here are the arbitration cases that have been reported from the courts. And it seems like the more we go to ADR to avoid the courts, the more people go to courts to avoid ADR. And so we see that. But if you want citations, if you send an email to me at J, the letter J, Grenig, J Grenig, at earthlink.net, I can send you a copy with the few citations that are in here if you'd like that. That's the easiest way on that type of thing. Let's just mention ADR for a minute. This is trying to decide things, resolve things, I should say, without going to trial in a court. You know, it could be through mediation, negotiation, arbitration. Arbitration is closer to being like going to trial because it's an adjudication. I like being an arbitrator. This year I've been married for 50 years, and as an arbitrator, at least there's one area where I can be in charge as the arbitrator, not at home. That's why we're married 50 years. It's because I know when to be agreeable. But as an arbitrator, you're in charge. And there's a lot of power, but there's a lot of responsibility. I have done lots and lots of cases in which people are discharged. You know, you say, well, it's just somebody and they did this. Yeah, but you know, you get fired. Yeah, well, where did you work last? Yes, and why did you leave? I was fired for stealing, or I was fired for this. You know, it's a very important responsibility. In another case recently, in a city in another state other than Wisconsin or Florida, involving firefighters, I ruled in favor of the firefighters on a staffing issue and awarded them over $1 million in back pay. So just because it's arbitration and just because it's ADR, and that's small compared to international disputes, that's just an employment dispute on that kind of thing. The city, by the way, is insolvent where the firefighters are, so I'm wondering when I'll get paid and when they'll get paid, but that's another issue on this thing. Arbitration, if you're not familiar with it, it's where it's not the same as mediation. Mediation is somebody comes in, and I like mediation. Let's see if we can work this out. I always say as a mediator, the less I say, the more likely it is to work. You don't raise their expectations or dash them. You just try to keep them talking, really. But you don't make a decision. You try to get them to reach an agreement. Arbitration, I make a decision, and it's final and binding. And it's very difficult to get overturned. I know probably in my 30 years of arbitrating, there's probably about 4 or 5 times at least they've tried to get my decisions vacated. It's never worked because it just doesn't work because the standard for getting it vacated is very high. Now, in arbitration, then in electronic discovery, let me just put it this way, discovery, the purpose is to take the gamesmanship out of it, not playing ambush, etc. That you should share whatever you're going to present in trial in support of your position. And we have provisions for formal discovery in which you can compel them to disclose things that you want. And discovery is very expensive. It's probably the most expensive part of litigation. Oh boy. Now arbitration, one of the reasons it's cheaper is there's less discovery. And there's generally speaking no discovery by rule. How many of you have taken federal civil procedure? Can you show me by hands? How many of you understand federal civil procedure? See, my hand didn't go up either. I didn't start to understand it until I started clerking for a firm. I had a teacher who was very interested in the common law forms of pleading. So we learned about trover and replevin and trespass on the case. Mr. Grenig, here's the hypo. Is that trespass or trespass on the case? Just to give you an idea of the kind of law student I was, there's a 50% chance I'll be right, right? The teacher, no. One teacher once, when I gave an answer, said, and he asked another student, do you agree with me? And the student said, oh, yeah. I mean, I don't know either. But, oh, yeah, I agree. The teacher threw his books up in the air and then said, you've known Grenig for a semester. He sounds good, but he doesn't know what he's talking about. So if anybody wants to leave now, that's okay on the thing. But the idea is to be, but there's a problem with that. Let me give you an example in a story. We've adopted 3 children and with disabilities, and one we brought up to the United States adoption about just short of age 5 from Chile. And when he had bilateral cleft palate, very serious, and as well as some developmental disabilities and stuff. But he's in for surgery every year until he's about 18, bone transplants, everything. Well, he's going to go, orthodontic work for cleft palate is considered to be a medical expense rather than dental, which if you understand that insurance, that's a big deal. Well, we have with all those, we went with an HMO for a while because it's all taken care of type of thing. So they approve in writing his getting orthodontic work. Based on that approval, we sign a contract for several thousands of dollars for his orthodontic work. After the contract is signed and they begin, we get a letter from the HMO saying, we've changed our mind, it's not covered. Oh. I says, well, I call up and says, what's going on? Where did this come from? Is there some information? What is the information that caused there to be a change? Oh, you want to go to arbitration? No, I just want some answers. Why was this authorization changed? Oh, you want to go to arbitration? That was the constant. You want to go to, no, I don't. I want to, let's talk first. What happened? Okay, then, okay, fine, send me the form for arbitration. And I fill it out, and then I send a letter. I want copies of all correspondence relating to this, from the authorization to documents, records as to why, who changed the decision, et cetera. And they said, oh, you'll get that information at the hearing. Oh, you mean you'll find out why we did it at the hearing. Oh, good, that helps me prepare. And they said, and I says, well, when are we going to choose the arbitrator? That's a hallmark of arbitration. You get to choose who the arbitrator is. And they said, oh, don't worry. We use a staff member who's very experienced. Now, my usual response probably would have been to scream and curse and do that, but no, be a lawyer. So I said, well, we don't agree with that. So I sent them a letter saying, I understand we have to go through with this, and if we don't, you're going to claim that we didn't exhaust all our remedies before we went to court. But I want you to be advised, we will not be bound by the decision where we don't have access to the documents that were involved in the decision and where you use one of your employees as the arbitrator. That's not fair. Something we sometimes don't use in law, but works. That's not fair. So I went on record as to we're not going to be bound by it, we object. And 48 hours before the scheduled hearing, they called up and says, okay, we'll go along with what you want. By the way, I got so good with them that they gave me the direct line to the person who was the final decider on approvals. And I'd call her up and I'd say, Joan, we got a problem. Okay, it's all squared away. But the lack of discovery can be a real problem. It is expeditious, but especially in consumer transactions, you're flying blind. In commercial transactions where both parties have information, then they're willing to because they want it and you want it, and so they know if they don't cooperate with you, you won't cooperate with them. But in consumer kinds of cases and insurance disputes, you as the consumer can be at a very great disadvantage without discovery. Now, the important thing to remember, and this is, I think, something that Bill wanted me to especially comment on. In court, you have a right to go through discovery. right? Rule 26. I have a co-author on a book, well, several books on discovery. And he says, let's divide up the federal rules. And you take rules 26, 27, 20. Some of you have looked at rule 26, right? That's over a third of the book. But it's just one rule. But under that, you've got rights to document production. What is that, rule 34? Rule 33, I think, is interrogatories. I don't memorize the numbers. Physical exams, requests for admission. But the rules don't apply in arbitration. What we do look for is some guidelines. One is the ABA discovery standards, which were amended in 2004 to address electronic discovery. They provide some guidance as to what is appropriate, but it's just guidance. It's just guidance. The federal rules of civil procedure can be helpful, but they're just guidance. They're not binding on me. I got a discharge case with an employee, for a state employee in another state than Wisconsin. These are public records, so I'm not going to give you names, but the public sector cases are public records. Mr. Grenig, I'm so-and-so, and I'm representing the state in this case. We would like to do requests for admission because we think the rules of civil procedure apply. I said, you won't, and they don't. And by the way, he presented his case this way. We have 4 affidavits here, Mr. Arbitrator, and that's our case. You have 4 affidavits. Have any of you ever tried to cross-examine an affidavit? On that. There's something, I don't know, have any of you talked about the Sedona Conference? The Sedona Conference, it's actually headquartered in Phoenix, but I think it started when an attorney from Chicago retired in Sedona. It's a kind of like a think tank, and it does papers on a variety of topics, including some very authoritative papers and guidelines and information on electronic discovery. And you can go to, do I have it here? No, I didn't put the citation here. Just discovery. Google Sedona Conference and you'll find it. And they have white papers and stuff that the courts find very persuasive and arbitrators find persuasive. The one warning that I would suggest to you to be careful with is that it is primarily Fortune 500 corporations and big law firms. I think the last time, I attended for a while, but it cost like $900 for 2 days. And the university had paid for other things, so I had to pay it out of pocket. That wasn't counting the hotel room. So I quit going, but there was like one plaintiff's attorney's firm, for that. So this is like Pfizer and Verizon and organizations like that. It's very good, very authoritative. I think it's good advice in there. But again, it's not, they're worried about the big case as opposed to the little case. Can you imagine being like at Pfizer, that's a pharmaceutical company, and I wonder how many notices they get a day that they're being sued. So when we talk about things like document preservation and stuff, holy moly, that thing. Electronically stored information is different than paper. When I started out practicing, it was paper. We had in the basement, I practiced in San Francisco, in the basement we had, which is about this size, we had rows and rows of filing cabinets. And my job was to go down in the basement. It was a building, one of the few that survived the San Francisco earthquake. The boss owned it, and my job was to go down, and the first thing you did when the elevator hit the basement is you turned on the lights and waited for the things that crawl to disappear. It was my favorite job on that. All paper, and you got to do this. Turn page after page after page looking for stuff. You couldn't do a word search or something like that. And one of my areas that I concentrated on when I was with the firm was construction law. And we were construction law like the San Francisco subway system. And the contracts are and specs are like that thick. And my job originally was to go through those contract documents and find a way to be able to sue, because they have filled with exculpatory clauses. We're not responsible for, well, what the heck do we, what are you there for? And we always found a way, but you had to spend hours, billable, hours looking through it. Now with electronic discovery, one of the problems is numerous locations. I don't know if you use the cloud to back up your stuff in, but you should be using the cloud. I hated it always when a student, I lost my comment for the law review, my computer crashed. Well, did you use Dropbox? Oh, well, you told us to, but I was busy. It's nice to have a cloud. When the Katrina came to New Orleans, the firm said, we have a backup system, it's in the basement. Florida, Houston, Louisiana, when it floods, what floods first? The basement. I use an external hard drive at home, which is about 4 terabytes, which is like 2 floors of this library it can hold. Because it backs up all the time, and so eventually it'll be 4 terabytes. But it's amazing when you think of how much that is. And so I've got an external hard drive, I've got Dropbox, I use iCloud for some things, and I've got my computer, which handles a gazillion gigabytes type of thing. It's a lot of stuff, and it can be, any of you ever, well, I was told that now if you're over 45, you still email. If you're under 45, I can remember my son would put on his resumes an email address, and I'd say, well, have you heard from him yet? Well, yeah. Do you check your emails? Oh, Dad, nobody emails. Kid, employers email. But it's all, for communicating with my wife and I, the 3 boys all do it. 3 boys are in their 30s. The 3 boys do it with texting. But people forward things. People in email. Okay, here's attorney-client privilege. You all know, attorney or whatever. So I send you my legal advice. You're my client. I send it to you, and you go, wow, this is good. I'm going to send it to the rest of the members in the class. Well, gee, have you heard of waiver of attorney-client privilege? It's so easy to do with email and with texting, et cetera. President Trump is frequently retweeting stuff. I mean, people, just because you can retweet, you can forward emails, et cetera. So suddenly you think, or you say, I know this is kind of improper in my Facebook page, but it's okay, it's protected by a password. Yeah, but the scoundrel who's got the password goes in and says, oh, this is good, I'm going to share it with all my friends. Well, now you're a character on, unless you're Kardashian, you'll probably be embarrassed by it. On that, it's so dispersible, and it can affect attorney-client privilege, et cetera. Plus, there's all these copies. I think, was it, I was trying to think who ran in the election. Hillary Clinton, that they discovered that there were other, like her assistant's laptop had stuff on it, which turned out to not to be anything new, but, and in fact, with Dropbox, my wife's laptop, my laptop, and my desktop all have, so you may have to search all these things. Yeah, they made me take my phone off. I was going to hold it up. I'm holding my iPhone up here. 256 gigabytes. That is 2 floors in the. That is more power, computing power, than the computer that took the lunar landing to the moon. The first computer I ever saw was in a building about twice the size of this room. And I walked, these things would be vacuum tubes, and I walked between, it's sort of like Honey, I Shrunk the Kids, and I'm walking through your computer. It was a big UNIVAC one at an Air Force base in New Mexico, and when they wanted to program it, they had to get in and change the hard wiring. And my dad started the computerized auditing system at the Arizona Bank. And but then there was a room about half this size, which was hermetically sealed, sliding glass doors, et cetera, with these big. Now, I don't know what I would do without my phone and without my laptop. And they have a lot of stuff in it. And that is important to realize because it costs a lot of money to search that stuff. And you say, well, I'll just give them my hard drive. I had an email from, I don't know if it was a former student or what, I hope it wasn't, who was saying, well, we've got this case going and we think we ought to be able to look at the other side's computers. Anybody here mind if I look at your computer and search it for anything? Do you mind giving me your Facebook password? Anybody willing? There's confidential stuff on there, for nothing else, financial. I don't want you to see my financial records. There's nothing improper in it, but it's none of your business. Equifax already gave that away. On that, there's a lot of stuff, and what are we looking for when we're searching? One, is it relevant? I don't think you need to know. I'm talking about planning my my bachelor party and who we're going to invite. That's nothing that you need to know about. But what about attorney-client privilege? Ooh. What about work product? Oh, and what happens if you disclose something that's protected? What happens? You lose the privilege. You lose the protection of the work product. Not really a privilege, but it's protected because there are ways you can get to it. And if you lose it for all purposes, for other cases, etc. So we have a problem with you need to search, and it costs money. Let me just give you a list, and some of you are already aware of these. I'm just going to say it very quickly. You don't have to take it down. These are sources. Removable media, floppy disks, USB flash drives. What's interesting with little USB drives is they now hold gigabytes. You know, it used to be, by the way, my first computer, well, I went to work with a law firm and we had dictating machines and they had gotten electric typewriters, but I had to take photocopies down the street in San Francisco. And they had a thing called, you may have heard about this, it may be in the Natural History Museum down there, carbon paper. And the secretaries would make like 4 copies of every document. Kind of thing. And I remember I got my first desktop and it had a floppy drive. It was about 6 inches by 6 inches, and it had one drive and it could hold maybe 20 pages or something like that. And then I got a computer that had 2 floppy disk drives. Whoa! I can remember one colleague at the law school saying, is there a way that you can take stuff that's stored on your computer back to your office at school and put it on your office? Yeah, I'll put it, save it to your floppy drive. And now we do it by internet through Dropbox and stuff like that. And then I finally got the little, I call them the Sony ones. What are they, 3 inches roughly, the little plastic, which were nice. They fit in your shirt pocket, and they didn't bend. And now a thumb drive. Some firms and some places don't like you to bring in to work your iPhone. Why? What is an iPhone? Anybody? What is it basically? It's a computer. Yeah, it's a little hard drive, isn't it? It's a little computer. It's amazing what it does. And you can connect it to here, and if I connect it to your computer, I could probably transfer to my iPhone a lot of your stuff in a very short period of time. I was doing a hearing in downtown Chicago for a big telecommunications company. And I had my laptop. I take my notes on laptop. And I go in, and they want to know I have to show my driver's license and information, and they look at it. Okay, fine. I leave. Now, all the executives have gone, and all the executives were from satellite offices, so I didn't know anybody in the building. And I go, and they say, excuse me, sir, do you have a laptop in that bag? Why, I do. Would you like to look at it? No, sir, you'll have to go over here. Okay, now they already have my driver's license number, et cetera, et cetera, et cetera. We need to know your social security number, and blah, 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 blah. I tore it up in little pieces, and I said, now get your, let me, how I can say, get your supervisor. I didn't curse, because that would not be good. Get your supervisor here now, because there's no way I'm going to give a rent-a-cop my social security number, my driver's license. Why don't I just give you my bank account numbers, and we can be done with it? So they called 2 people in suits. Took me into an office with it wasn't your office, Bill, but it was an office with no windows. Well, sir, what seems to be? Did you throw something at her? The person, I can't remember, her, him, whatever. I says, yeah, right, I don't think so. You try tearing that up, and how far are you going to heave a torn up little piece of paper? And I said, I'll tell you what, you'll like this as students on that thing. I'll tell you what. If you don't let me go, I'm going to miss my train. If you don't let me go in the next 10 minutes, you can look at my computer. Look at it, it's mine. I'm taking notes for a hearing, and those are confidential. But you can look, I'm here for a hearing. I'm not going to let you search the whole thing, because I've been taking notes, and the notes are private. But I says, if you don't, I've got several former students that practice law down the street, and I will have one of him or her, one of them, there we go, one of them here in a few minutes, and we can talk about, what is that, false imprisonment? Well, sir, you can go. Sure you don't want to look at the computer? No, sir, you can go. Thank you. You know, protecting your computer is hard. No, they haven't sold them yet. Is anybody going to get the iPhone with the facial recognition? They're only, what, $1,000? Whoa. Let me ask a question in this room. How many of you have cell phones? All of you? How many of you have cell phones that are not smartphones? You know, they're just a clamshell that you can call. My mother's, those one. My mother's so old, she's in her 50s. We have to get her a special cell phone. Yeah, right. On that, how many of you have a landline phone at home? Anybody? One? Two? Okay. I was thinking in the building, I was looking for just to see if there's a payphone. I don't know if there's a payphone. I mean, payphones have disappeared. When I go to conferences, I'd leave at the break a few minutes early so I could beat the rush to the payphone to check with the office. I mean, yeah, look at you. I don't know. Oh, that's funny. Did they have payphones in caves? One of the things, there's so many things to look for. Let's just go to some of the, here we go. Let me look at some of the different kinds of ADR. Labor arbitration really doesn't have discovery as such. Labor arbitration under the labor law as it presently is constituted requires the parties to exchange information as part of the bargaining process. And if they don't, then it's an unfair labor practice. Those of you, I haven't taught labor law in many years. 8A5, is that what it is? It's unfair practice, failure to bargain. So they don't really do discovery other than that one case where I want to follow the rules of civil procedure. No, you want. First of all, I'd have to figure them out, type of thing. And secondly, they don't apply. So labor, it's not a big issue. There's a duty to disclose. When I first started talking about electronic discovery, I was seeing one of us just, what do you call it, emails that were printed out, and there was no question about metadata or any, everybody agreed that's the correspondence. Then I did lots of hearings at prisons involving prison guards. Well, if you work at night, you're in a bubble, they call it, a glassed-in thing at the, in various places, and you have a computer. What do you think they accessed on their computers? Yes. So somebody says, why do you keep talking about pornography with electronic discovery? Because I says, for 5 years, that's all I've been seeing, electronic discovery. Of course, then you take the printouts. They showed them to me as printouts home, and your wife sees on your desk this printout, and she's going, what are you doing with that, honey? It's evidence. Yeah. One of the first cases I ever had actually involved a foldout. A school janitor put a foldout from Hustler magazine on the roof of his janitorial closet, and one of the 7th graders discovered it. Mrs. Jones! And then the idiot, so I had that on my desk at home. What is this here for? But pornography is a big thing on searches, and people get fired, teachers especially, prisoners, et cetera. The biggest problem with the porn, not the metadata, it's authenticating that's for evidentiary purposes, laying the foundation. I think I had one in which an employee, they had a program, there's programs that can, at work, that can trace where you're accessing. If you put down naked girl, it says when you looked at naked girl and for how long. And this is what caught him. And the question was, they said, well, the employer, they put it up on a big screen. And they said, well, the employer hasn't laid a foundation that this is the picture he looked at. And I says, I think naked women wanting dates in Wisconsin probably says it all. And common sense would say that may not be the picture, but we know what he was looking at. And so there were some other issues in it. But that can become, but trying to authenticate what people have seen on websites is very important. Employment and commercial arbitration, You may have the rules of the American Arbitration Association, which says the arbitrator has discretion to allow discovery. But you don't necessarily have American Arbitration Association rules. I'd say over half of the case, I haven't done an American Arbitration Association case in probably 5 years. And I do lots of arbitrations. They just aren't used much in Wisconsin and Illinois, even in the areas that I work in. They're just not used. And I travel around the country doing cases and not. So the rules don't apply. And in commercial, now one of the problems, let's look at it, that people will say in their agreement, we agree that the arbitration will be governed by the rules of the American Arbitration Association. Go to ADR.org, see I remembered that site, go to ADR.org and you will see about a dozen or more rules. Commercial rules, construction rules, international rules, employment rules, labor rules. They never say which one, consumer rules type of thing. That's all they tell you. You have discretion to allow discovery. And I don't know. I sometimes say to law students, that's good. You don't have to memorize a rule like personal jurisdiction. The court never agrees on it, so you just talk about it. And you'll get something right on it. If there's no rules or there are rules, the arbitrator still has discretion. And there's a lot of responsibility. Should I allow them to have free wheel, but I don't want to, you need to get some basic. We'll talk about that in a few minutes. Interestingly enough, in the American Arbitration Association rules, the construction rules of the American Arbitration Association provide some information as to what the arbitrator should consider, such as dealing with confidential information, search parameters, allocating the costs. You need to consider the power to impose sanctions, all of those things you look at. So they give you a little guidance, but the arbitrator has discretion. In the cases which I cite in here, the courts always say when somebody complains about what the parameters were for discovery, if any, it's the arbitrator's decision. And by the way, judges I didn't learn this in law school, but until I went to speak before some judges a few years ago, somebody's talking about recent decisions, and they all want to know which ones was it talking about discretion and which ones was there an absolute duty. And they are very sensitive to we have the discretion to do this versus we have the requirement to do this. Arbitrators have the discretion. International arbitration, depends upon where you are, what you're going to get. Civil law countries do not like, which include France, not England, it's a common law country. France and Germany, Japan. Japan, after World War II, based its legal system on German civil law because I think they may have done that actually before World War II. Their system, they said, we like the civil code, but we like German because they respected the Kaiser. So it must have been before World War II. Type of thing. They go for German, most Japanese professors. I gave a speech at the Osaka Bar Association about 4 years ago this October. And first question they asked was, how old are you? Well, age is honored, and remember that. I said over 21, and they all laughed. They were very polite. And then I told them my age. So this, which means really. And I was cool then, because I was old on that type of thing. International arbitration, they were shocked that the American Arbitration Association had changed its international rules and gave arbitrators under those rules the discretion to permit discovery. They were shocked that an arbitrator would permit discovery. They have document exchange. You have to exchange what you're going to use in the case, but you don't have to exchange anything else. And they were, that was the discussion, was across the table and everything as to, man, we don't like that. We don't like that. If you go to some places like, it changes, but Japan, England to some extent, and Switzerland, and if you say, I'm coming here to do discovery, England has some blocking statutes which really protect trade secrets. And like in Japan, yes, Mr. Grenig, and what are you doing here? I'm an attorney and I'm here to take some depositions. Really, Mr. Grenig, let me show you where the next flight is out. They don't like that. I mean, you got in international, you better be very aware of where you're trying to get. Also, the tribunal. If you have arbitrators that are from France, Italy, Germany, discovery. You're talking about Columbus? They don't like it on that thing. Let me talk about several issues. We're good on the time. Professor Hamilton and I were talking after you teach for a while. You get this sort of internal clock. Except for, do you ever have teachers that have never ended a class unless it's at least gone over 5 to 10 minutes? Our dean did that. When they would schedule me after his class, he'd say, Jay, can we start you another 10 minutes later? Because I always go late. I end on time. There's hope on that thing. One is there's a duty to preserve in regular court litigation and also in arbitration. Arbitration, we don't have a jury to give an adverse inference instruction to, but for example, I can issue subpoenas. I can sign them. Here you go. You serve it. But I can't enforce them. But I can say this, well, if it's a subpoena to the other party, not to a third party, I can say this, well, if you're not going to produce that evidence, I could take an adverse inference that why you didn't present it is that it's going to hurt you. So I'm not good at raising my eyebrows. My wife can do that and makes me nervous. Really? But in a sense, I'm raising my eyebrows saying, are you sure you don't want to present it? Because if you don't produce it, I'm going to maybe take an adverse inference, and it usually shows up on that kind of thing. So duty to preserve, and the duty to preserve applies to both parties. Sometimes, let me use the words plaintiff and defendant. Sometimes I've had plaintiffs' attorneys call, now how do we get the defendant to preserve? And you should do this in arbitration. You should send out a litigation hold in arbitration to preserve this information. But you should also tell your client to preserve it. When they come to you and say, we want to sue, okay, good, we're going to sue. Right now, you're on notice that there's a likely lawsuit. Why is it likely? Because you're going to file it tomorrow, and you tell your client, preserve. Preserve. Now, I won't go through the forensic parts of how you preserve, but you got to preserve it but I don't think it hurts in arbitration to send out a litigation hold letter to the other side, but make sure your person does it. And it's not just what's on a computer, it's digital information. I mean, there was one case involving sexual harassment in which the complainant deleted everything on his iPhone before the case started. Any of you have photos on your iPhone? I have. And some of mine are iCloud. I don't know if they're on the phone, but there's a lot of photos on mine. Oh boy, why did he delete them? I don't know. Duty preserve, I don't know. But generally, by the way, this is always a good one. I imagine that Professor Hamilton talks about this is people who go and buy evidence eliminators, the software, evidence eliminator, and then they put it on their computer and it eliminates everything. But of course, it leaves us saying it's been deleted by evidence eliminator, and you're the judge or the arbitrator, and you look at this says you used evidence eliminator. Was it just an accident? What was it? Tom Brady. I couldn't think of his first name. Tom Brady with his cell phone at the arbitration. Oh, I happened to lose the one on which all the communications involved were made on. That might have been spoliation. First time, by the way, I saw spoliation. Have you talked about it yet on spoliation? Okay. First time I thought spoliation, I says, oh, that's misspelled. It must be spoilation. I mean, I never heard about it. I mean, I knew you couldn't destroy evidence, but now, and there was a comment made about by the way, if you're wondering on the NFL cases why these not impartial arbitrators, the commissioner, et cetera, that's what the collective bargaining agreement says. The union agreed that the commissioner or his or her designee could be the arbitrator, but they don't have it in the next contract. One of the things is if somebody says it's a hardship to preserve, tell them they got to preserve it while you decide whether they're going to have to produce it. I think in arbitration it's appropriate to require the parties, if we're going to have discovery, that you talk about it first. See if you can come up with a plan which includes what are you going to look at, search terms, scope, blah, blah, blah. You can borrow from Rule 26F, is that it? On there. You can borrow from that idea, but let them try to work it out. They're in a better position. On the other hand, if you're getting paid $400 an hour, maybe you make sure you bill by the month. I think a plan that they should come up with a plan if it's and you get huge commercial disputes. You're not going to see that in a consumer dispute for $50 with Verizon, but that arbitrators should talk about what they should talk about, and the arbitrator needs to be sure they do the form. It could be this is ESI. This is electronically stored information here, and it's in hard copy, but it came off of my computer at home, and so you're going to have it paper copies. In the class, I guess I can ask, why would you want a paper copy? And you might, type of thing. I think you have to look at proportionality as an arbitrator if they're requiring it. A mutual friend, Dan Connolly, referred to it as electronic blackmail. That is, we're suing. Professor suing me for, let's say, $50,000 for something, and he puts in a discovery request that's going to cost me $120,000 to search and review. You'd expect it of him, wouldn't you? $120,000. You got a choice. You can settle for $50,000. You can spend over twice that on discovery, and even if you win, you still spent $120,000. The arbitrator should look at proportionality. Should somebody be required to spend $1 million to search for things when the case is $50,000? So you're looking at what is the value of the case. One of the problems can come up, though, is the cash value may not be important, but there may be important principles involved that may not be what would you say, quantifiable in terms of dollars. But that's something you would have to look at in this thing. I've got in this thing, like I say, if you want to send me an email, I'll send you. I list some of the things you might want to look at on proportionality. Where are we borrowing those from, by the way? The ABA standards on discovery and the Rule 26 when it talks about proportionality. I mean, there's some good guidelines. I'm not bound by them, but they do give me something to think about on that. Let me talk briefly about subpoenas to third parties. I can issue subpoenas. This happens. This is not necessarily an arbitration case. This is a litigation case, but let me just kind of give you this idea. Person's in an accident. The defendant, shortly after the accident, the defendant puts on Facebook, "Wow, I'm sure glad they didn't give me a breathalyzer test because I'd had 6 beers at the party before the accident. What a party. That was really a blast," on Facebook. So attorneys are looking to Facebook for information because people are, stupid about their protecting their private interests and stuff on Facebook because they think, well, it's private. There's that. What other group of attorneys do you think like to look at Facebook? Personal injury. Well, that's personal injury. There would be, how about divorce attorneys when it's hard fought on custody? Let me show you what he has on Facebook with his girlfriends. And I say his girlfriends because 90% of the time he's the one, not all, but. So divorce attorneys are getting very good at this. So subpoenas to third parties is a very hot issue. Arbitrators can issue them, but we can't enforce them. 2 last things. One is on the, by the way, here's a number for you if you like numbers. The Rand Corporation 5 years ago estimated the cost of reviewing and producing ESI as $18,000 per gigabyte. My phone holds 256 gigabytes. It's not full, it's about, but photographs, iTunes, etc. It's not that surprising. I figured out that it would have cost me approximately $16 million, if that's the cost, to collect and review all the ESI I have on my computers. Oh, and last thing is, we can bring sanctions, but the main sanction is negative inference, adverse inference, or requiring somebody to pay attorney's fees. That's about it.
Professor Grenig, thank you very much. Let's give him a warm gator. Thanks.
Thank you.
We're going to retreat now, if you will, back up to our regular classroom, 355C, at 2 o'clock with Professor Grenig to talk about themes that popped up out of this presentation. Anyone not in our class is welcome to join us. So we'll see you all up there in 10 minutes. Thank you.